£59 million. That is what HM Land Registry stopped in fraudulent property applications in a single financial year. That is the figure they can publish. The amount that was not stopped goes untracked. The fraudsters needed no key, no crowbar, no visit to the property. They needed a form, a forged signature, and a system that processes millions of applications every year without ringing anyone first. There are 5 documents every UK homeowner over 60 needs right now. Most people have none of them. I spent 4 decades inside the UK tax and financial system, most of that at HMRC. For the last several years, I have been volunteering at Citizens Advice, sitting across the table from people in their 60s, 70s, and 80s who paid off the mortgage, stayed out of debt, saved carefully, and then found that one of these 5 gaps had cost them dearly. I'm not on the payroll anymore, which means I can finally say a few things I wasn't allowed to say before. 1. Property alert. Free, 10 minutes. Do it now. Your home sits on a live register, not a dusty file in a cabinet somewhere. A live digital record that anyone can submit an application to change. A transfer of ownership, a new mortgage, without ringing you first. That is how the system works. And that is how property fraud works. And here's the bit nobody explains. Property fraud does not look like a burglary. It looks like a form. A fraudster identifies a mortgage-free home with an older owner. That search takes 30 seconds and is entirely legal. Title information is publicly available. They create a forged transfer document and submit it. In the 2024 to 2025 financial year, Land Registry stopped fraudulent applications against more than £59 million of property. That is the stopped applications. The ones that succeeded go untracked. And the profile of who is most at risk is specific. Mortgage-free properties, older owners, homes where the owner does not live full-time. Land Registry publishes that list. I looked at it. I was most of the things on it. Land Registry runs a free service called Property Alert. Go to landregistry.gov.uk/property alert. Create an account, enter your address or title number. Every time significant activity is registered against your title, an ownership application, a new mortgage, you receive an email. You can monitor up to 10 properties. You do not have to own them. Your adult children can add your home to their own account. I sat with a woman called Sandra at Citizens Advice, 67 years old, paid off home in a village where she had lived for 30 years. She had no idea the register was publicly searchable or that applications could be submitted without her knowledge. I assumed Land Registry would just contact me, she said. Land Registry processes over 4 million applications a year. They do not contact individual owners before registering changes. Don't be Sandra. If you receive an alert you do not recognize, ring Land Registry's fraud team immediately. Say, I have not authorized this application and I believe it is fraudulent. They can halt it while they investigate. 10 minutes to register. Free. Do it before this video is off your screen. Scotland. The equivalent service is Registers of Scotland, not Land Registry. The process differs. Search Registers of Scotland Property Alert for the Scottish version of this protection. Right. 2. The form L. Restriction Property Alert tells you after something has been submitted. The form L restriction makes your home harder to target before anything reaches the register. And here's the bit nobody explains. When this restriction is entered on your title, no sale, no mortgage, no transfer can proceed unless a solicitor certifies in person, in their own name, that the person signing the documents is the registered owner. Not by email, not by a member of staff. The solicitor themselves, face-to-face, in writing. That matters because almost all property fraud relies on one thing: someone pretending to be you. A Form LL restriction means the fraudster who forged your name now also has to deceive a regulated professional in person. That is a considerably harder thing to do. This protection is not for everyone. If you live in your home and nothing unusual is happening, the property alert alone may be sufficient. The Form LL restriction earns its cost for landlords, for people who spend significant time abroad, and for older homeowners living alone in a paid-off property. Exactly the profile most commonly targeted by fraudsters. I sat with a man called Gerald at Citizens Advice, 69 years old, rental property, owned outright, tenants in place, 40 miles away. He had never heard of either service. I just assumed land registry would flag anything unusual, he said. They process applications. They do not flag them to owners. Don't be Gerald. Apply through Land Registry Form RX1. There is a small fee and most people use a solicitor. Factor in that the same solicitor will need to verify your identity when you eventually sell or remortgage. This is worth one conversation with your conveyancing solicitor this month. Scotland. Registers of Scotland handles property restrictions differently. Take specific Scottish legal advice rather than applying the RX1 process directly. Now. 3. A lasting power of attorney for property and financial affairs. Most people assume that if something happened to them, a stroke, a fall, a diagnosis, their spouse or children could step in and manage things. They cannot. Not automatically. Not legally. And here's the bit nobody explains. Without a registered lasting power of attorney for property and financial affairs, nobody, not a spouse, not a child, not a trusted friend, can sell your home, access your accounts, or make financial decisions on your behalf, not even temporarily, not even in an emergency. The alternative is the Court of Protection. The application fee is £371, annual supervision fees after that, and it takes 4 to 6 months to process, during which nothing can happen with your property or finances. Nothing. Everything stops. I sat with a man called Derek at Citizens Advice, 69 years old. His wife had had a sudden stroke. She had managed their household finances for decades. Several accounts were in her name. He did not know who their energy provider was, what standing orders were running, or where the insurance documents were kept. They had wills, proper, well-drafted wills, no lasting powers of attorney, 3 months of trying to manage their affairs with no legal authority to do so. Why did nobody tell us about this? He said. I didn't have a good answer. Don't be Derek. The government registration fee is £92. Most people make 2. 1 for property and financial affairs, 1 for health and welfare. Total cost, £184. If your annual income is below £12,000, or you receive certain means-tested benefits, reductions and full exemptions are available. Make it before you need it. Once capacity is in question, the process becomes slow, uncertain, and considerably more expensive. Scotland. The equivalent is a continuing power of attorney, registered with the Office of the Public Guardian Scotland. Northern Ireland uses an enduring power of attorney. Different forms, same essential protection. Right. 4. A deed of severance and property protection. Trust most married couples in England and Wales own their home as joint tenants. Joint tenancy has one rule. When one of them dies, the other takes the whole property automatically, regardless of what the will says. The house passes by survivorship before the will even has a chance to operate. And here's the bit nobody explains. When the surviving spouse owns all of it in their sole name and subsequently needs residential care, the local authority carries out a means test. In England, the capital threshold is £23,250. Above that, you fund your own care in full. Residential care costs more than £1,400 a week on average. A home worth £250,000 can be consumed in under 3 years. The will your spouse made to protect it? Never operated. Survivorship happened first. 2 documents change this entirely. First, a deed of severance, which converts the ownership from joint tenants to tenants in common, giving each of you a defined share. Second, a will that includes a property protection trust. When the first of you dies, your share passes into a trust rather than outright to the survivor. The survivor retains full rights to live in the property, to sell it and move if they wish. to treat it as their home in every practical sense. But the trust share is not in their name. It cannot be counted in a means test. When the second of you eventually dies, the trust ends and the share passes to your children. I sat with a woman called Barbara at Citizens Advice. 71 years old, her husband had died the previous year. The house had been held as joint tenants. The whole property was now in her name. Her husband had spent his final weeks reassuring her that everything was sorted. He had a will. The will never operated. The survivorship happened first, and everything he had intended to protect was now fully exposed. He was so sure it was all in order, she said. It was not in order. Don't be Barbara's husband. Find out this week how you hold the property. Download your title register from gov.uk/search-property-information-land-registry for a small fee. The ownership is listed in plain text. If you are joint tenants, speak to a solicitor about a deed of severance and a property protection trust in both wills. The severance is a form. The trust goes inside the will. Both are required. Scotland. Scottish property law and care cost rules differ significantly from England. The concept of joint tenancy does not apply in the same way. Take specific Scottish legal advice rather than applying what I have just said directly. Now. 5. Your title register and your council tax bill. This is two things. One takes 5 minutes and costs you nothing. The other surprises almost every person I raise it with. The council tax first. If you are the only adult living in your home, you are entitled to a 25% discount. It is not applied automatically when circumstances change, when a spouse dies, when an adult child moves out. Ring your council tax office and ask whether your current bill reflects your household. Ask about the council tax reduction scheme while you are there. Income-based, administered locally, and it can reduce the bill to nothing. Most people who qualify have never heard of it. And here's the bit nobody explains. A mortgage-free home is not automatically protected from creditors. If a creditor, a credit card company, a loan provider, any civil debt that goes to court, obtains a county court judgment against you, they can then apply for a charging order. A charging order is registered against your property at land registry. When you sell, they are paid from the equity first. The home you own outright is not untouchable. It never has been. I sat with a man called Jeff at Citizens Advice, 68 years old, retired, credit card debts from a difficult period in his early 60s, a county court judgment letter that had sat in a pile on the hall table for longer than he wanted to admit, a charging order registered against his home while he was living in it, paying his bills, assuming the property was safe because he owned it outright. I thought that meant it was mine, he said. It was his, and a creditor's charging order was registered against it. Don't be Jeff. If a court claim form arrives, respond to it. If a county court judgment arrives, ring Citizens Advice or a debt charity the same week. Do not put it in a drawer. And to see what is currently registered against your property, download the title register from gov.uk/search-property-information-land-registry. Any charges are listed there in plain text. Scotland. Council tax rules and court processes differ in Scotland. The principle on respond to all court correspondence immediately applies everywhere. The system runs on what you ask for, not on what you're owed. Set up the property alert today, before this video ends. Ask a solicitor about the Form LL restriction if you fit the profile. Make the lasting power of attorney before you need it, because once you need it, it may be too late. Find out how you hold the property and ask about the deed of severance this month. Download the title register and ring the council tax office this week. That is where we started. £59 million of property fraud stopped in a single year. The amount that was not stopped is not published. Your home is the most publicly documented thing you own. Anyone in this country can find it online in 30 seconds. These 5 documents are the 5 ways to make sure that public record does not become a vulnerability. None of them are complicated. The property alert is free. The LPA costs £92. The title register is a few pounds. Not one of them will arrive in a letter. You have to go and get them, take care of yourselves, and take care of your home. I should say, as I always do, decades inside the UK tax and financial system, and now a citizen's advice volunteer. Nothing here is regulated legal or financial advice. For your specific circumstances, LPA, property protection, care costs, speak with a qualified solicitor. For pension or financial matters, speak with a qualified independent financial advisor. All links and services mentioned today are in the description.